Good afternoon, everybody. I have the enviable position of being immediately after lunch, so we're going to do everything we can to make this as entertaining as possible. I decided not to tap and sing starting, but we're just going to go straight in. I'm Michigan State Senator Lana Theis. I'll be chairing the meeting today. I need a motion to waive the quorum requirement. Thank you, Representative Carter. Second?
Second.
Thank you very much. All in favor? Aye. We'll start today with a continued discussion on structured settlements, and before we begin, there's a little bit of background. INCOIL has an existing Model State Structured Settlement Protection Act, which you can view in your binders on page 107 and on the website and app as well. The model was amended during the summer of 2022, and since that time, there were some requests to have the topic back on the agenda to further educate the committee on structured settlements. We did discuss this topic at our spring meeting in April, and now we're going to have some new perspectives on the topic as we're going to hear from some presiding judges. We'll start by hearing from David Rose on behalf of the National Structured Settlement Trade Association alongside the Honorable Victor Lopez, a New Mexico District Court judge. Susan Staus, who is listed on the agenda, had a conflict come up, so David is filling in for her. Go ahead, David.
Thank you, Chair Theis. It's great to see you here. I appreciate the opportunity to fill in for Susan. She is by far the expert when it comes to this, and I will, first of all, I'm surrounded by two judges, so I'm a little nervous here. So I hope I do okay. And also, I would, being from MetLife, my name's David Rose, and I'm a part of the State Government Relations team with MetLife. And being with Met, I would just like to say thank you to INCOIL CEO Tom Considine. He is a MetLife alum. He's always told me that he will have a retirement coming from MetLife. So we're very proud of Tom and just want to wish him well in his next endeavor. So thank you for that personal indulgence. MetLife and other members of the National Structured Settlement Trade Association are grateful for allowing for you, Chairwoman Theis, and the leadership of INCOIL to continue this discussion of the Structured Settlement Protection Act. Especially Senator Utke. I know this is something that's near and dear to his heart. He's worked on it closely in his home state of Minnesota and here at INCOIL, so we look forward to continuing the discussion with yourself and with Senator Utke and the other members around the table. Today we're going to hear the perspective of the judiciary. As I said, we have two judges here. I am pleased to introduce Judge Victor Lopez. He's a district court judge in the great state of New Mexico, which incidentally, many of you probably remember that the original Structured Settlement Protection Act at INCOIL was sponsored by New Mexico Senator Carol Lavelle. I hope I'm pronouncing that correctly. It was before my time here. But so that perspective, I think, is useful from Judge Lopez's experience. Judge Lopez, his biography is in the program that you have before you, so I won't go into that in detail. But I will just point out that as a part of his judicial work over the years, many years, Judge Lopez on a monthly basis considers at least 2 to 3 petitions to approve structured settlement transfers. So without further ado, let me turn it over to Judge Lopez for his comments and perspective. Thank you.
Thank you, David. I appreciate the introduction. Chair, members of the committee, thank you for hearing our concerns here today. And also I want to thank INCOIL for asking me to come to the beautiful state of Texas, San Antonio, to share with you today. As a district court judge, I do regularly hold hearings to try to determine whether structured settlement payee, which we can also call a transferor, because they're the ones that are going to eventually or possibly transfer their settlement to a factoring company, whether they should be allowed to receive from the factoring company a deeply discounted payment in exchange for the transfer of these benefits to the company. I'm here to provide the committee with an understanding of the information that judges need to provide or that they should be provided so they might make an independent determination as to whether it is in the payee's best interest. That's the fundamental concept that we consider is what is in their best interest. It's a sort of paternalistic role, and we don't have a lot of information given in this process. But let me put it in this way. I was having breakfast this morning, and a person sitting next to me was talking about an auto accident she had recently that required her to purchase a new vehicle. Sounds like it might have been serious, given that situation, but she was fortunately not injured in the accident. But if she had been injured, and if she had sustained damages of, say, $1 million to compensate for her injuries, her settlement might have been placed into a structured settlement, which would include a future stream of fixed periodic payments. Those are the kinds of situations that we deal with and that this statute deals with. Because after you receive such a settlement, and then factoring companies might learn about the accident, or they might solicit her generally in the media with regard to selling of her settlement rights. Normally, you receive a long stream of payment over many years. The idea there, under federal law and under state law, is to make sure that those funds are not dissipated over time. And so there are some built-in protections. But possibly, and one of those protections is having the judge review the situation. But a factoring company might learn about this and offer to sell or offer to purchase the rights to meet immediate needs. I've had many people come before me where they need to repair a transmission or pay credit card debt or pay down a home or pay for a down payment on a home. The reasons are quite varied. At this point, after the original tort case, the victim has probably discharged her personal injury attorney and just hears from the factoring company, either by telephone calls, internet, or television commercials. I have seen requests where factoring companies might offer to buy let's say, $1 million structured settlement for pennies on the dollar. Some as low as 50%, 30%, or less of the future payout if received over time. And these tort victims can only see dollar signs and are happy to get or to receive a fractional payment to meet immediate needs rather than having the patience to wait for the stream of payments to be paid out. This is an unfortunate situation in many cases because it's hard for the judge to really know, to have enough information to know whether this makes sense or not. The primary problem with structured settlement transfers in this area is the disparity of bargaining power between the injured tort victim and the factoring company that seeks to purchase the victim's structured settlement. The factoring company has an attorney, while the victim has neither an attorney at that point, also doesn't have an advisor or even a guardian ad litem to speak up in my court about the advisability of the transfer. The judge serves in the paternalistic role of deciding whether the proposed purchase is in the tort victims, and I'm going to call them the tort victims, but we can also call them the transferor, whether it's in the tort victim's best interest for that money to be paid out and for them to take such a big hit on the value of that. Essentially, the judge is there to make a best interest decision with his or her hands tied behind their back. The factoring company's attorney only presents the bare minimal facts about the terms of the transfer, but says nothing about the tort victim, also known as the transferor. We sure could use an option within the statute, and I think the NCOIL is talking about this, to appoint an advisor or a guardian ad litem, we can call them a GAL, to review the case before the hearing and provide the judge with a report so that we can prepare for the case and be prepared for that and ask questions. In New Mexico, we do have the authority to appoint GALs prior to holding a hearing on approving settlements involving minor children or incompetent adults. Usually the GAL will recommend approval of the settlement, but other times they may say no because of lack of information, medical care issues, or it's just an inadequate to fairly compensate the minor child. Certainly, judges tasked with deciding structured settlement transfers can use such a procedure to appoint GALs and review their reports in advance of the hearing to make sure that we consider necessary facts in advance of having to decide the petition. But we need the statute to be amended to allow the judge the discretion to make such a GAL appointment paid for presumably by the transferring company. Under federal law, a fundamental goal of structured settlements is to set up a stream of future payments to protect against the victim becoming a burden on the social benefit and medical programs that we have. The problem is that judges only hear from the factoring company's attorney at our hearings without input from a professional to present the tort victim's interests. For example, how did the original accident occur? How was the victim injured? Was there a head injury involved that might affect the victim's capacity or decision-making? Does the victim have dependents, children, a spouse, a mother, for example, who would be affected by a transfer of the negotiated future payment stream? The payee's current and future living medical and other needs and those of the dependents need to be considered. Now, did the payee attempt to do prior transfers of structured settlements? Because we do see a lot of repeat business in this area. And some of these initially are turned down. And so they try another judge by refiling. These victims normally do avoid these discussions when that does happen. Judges just don't know why prior petitions were denied, but it would be helpful to have that information so that we can figure that in and put that into our overall decision-making with regard to, or maybe the other judge had a real good reason for denying it at that point. We'd like to know that. And so the judge just does not have the facts at this point, and we would, was that my bell? Am I? So at best, during the hearing, we hear from the injured victim only vague recollections of the past incident, but they will explain how they need the money today to fix a car, to start a business, or to pay credit card debts. Judges need sufficient information in the petition process and the GAL report testimony, including the victim's sworn testimony in affidavit form about their background, the accident, the dates when the accident occurred, dependents, and other essential factors. If we're going to be able to engage in the meaningful best interest review, which it's hard to do at this point, we're just not receiving the information, and some inexperienced judges might decide to accept what little they get, while other judges may just deny the petitions. And this process, in my view at least, makes no sense. So I'm here today to ask you to bring some reason to the process and to consider amending the model statute, the Model Structured Settlement Protection Act, to help improve the fair administration of justice by getting judges more information so that we might make the best interest decision guided by necessary facts at hand. And I stand for questions. Thank you very much.
We could do it later.
Senator, and then Representative, and then...
How you all doing today? Good to see you. I'm just a little country lawyer from New Hampshire, sort of like Spence used to be, if you remember him. My question would be, why is it I don't like the best interest standard in this case. I would think as long as I'm a competent person, if I was incompetent, or you had some reason to think that I was under duress or something, I could understand you getting involved. But if it's my decision, why shouldn't it be my money to take it and do as I please?
Right, right. No, that's true, and that's one of the views that is being presented, especially in the advertisements on television. I hear it all the time. But what you have to realize is that there's a strong lobby there that really promotes this process, because this is a billion-dollar industry. And so the person that we receive information from, well, we receive very little information. We hear them at the hearing. These hearings are by telephone or by video generally, and so you don't see the whites of their eyes essentially. And it's hard to judge their credibility. There's no adversarial process involved where you have an attorney on one side or the other developing the facts. You just have one attorney, and they're the attorney representing the factoring company. So it's hard for the judge to assess that. But the federal intent originally was to make sure that the stream of payments were going to be sufficient to carry this person into the future, and that is totally defeated by allowing these payments to be terminated before the time and at a hugely discounted rate. That is the problem. It becomes a social problem. Thank you.
Thank you. We're going to wait on the questions until later on, so I'm holding myself up to you, Representative. We have also Brian Deere of the National Association for Settlement Purchasers, the Honorable Omar Maldonado, County Court Judge from Texas. So Brian, if you'd like to go ahead.
Thank you very much, Madam Chair. And first, it's being someone who is both the Executive Director of the National Association of Settlement Purchasers and also a practicing attorney here in the great state of Texas. Welcome to the great state of Texas. I hope you're having great Mexican food while you're down here. I just had a little meat here. If you haven't been there yet, by all means, get some enchiladas, go see some mariachis. Excellent performances over there if you want them, just down the street. But first, thank you again for having me back. I had the opportunity to speak with you briefly in Nashville on this important topic. Our organization, as many of you are well aware, has been working with NCOIL, as well as Senator Utke from Minnesota during the recent legislative cycles in Minnesota, South Carolina, and in other states on this issue. And I certainly understand some of the judges' perspectives, and I have brought you this afternoon one of our finest judges from the Rio Grande Valley, Judge Maldonado, who I'll introduce a little bit more in just a second. I did want to top, kind of going to the gentleman from New Hampshire's comment. The best interest standard, I think, just very briefly, I did want to touch on that, is important. And one of the things I think is very important that we never forget on these types of cases is that every single one of these cases involving one of these structured settlement transfers is someone's story. Every person comes from a different walk of life. You have some people involved in these transactions who are injured in an accident, some minorly, some severely. You have some people who are receiving these structured settlements as a result of a wrongful death case. And we have people in these transactions that come from all walks of life. In this last week, I had a person here in Harris County on a case that one of my clients brought to court that involved the payee in that case was an attorney. She had her own consulting business. She entered into a transaction to sell a portion of a structured settlement that she received as a result, unfortunately, from the wrongful death of her mother in a plane accident. And after essentially exploring her options, she discovered she could get a far better deal selling her structured settlement at an 8% rate than she could from hard money lenders to expand her business. So there's a lot of talk about people taking advantage of folks in this industry. But I do want to make sure that we focus on each individual because every person's story is different. We have people who absolutely fall on hard times and are trying to lift themselves out of a difficult situation. We have very sophisticated people involved in some of these transactions who are lawyers, who are doctors, who are accountants. Those are people who do not necessarily need to have a guardian ad litem tell them, review everything about their lives to say, you should listen to me. lawyer who's been a practicing person for many years. Let me tell me everything about your life, and I'll tell you what's best for you. Now, in certain circumstances, when the court finds it appropriate, we absolutely support an ad litem appointment. And that's something that judges have the existing ability to do under their powers. In any case a judge wants to have an ad litem, they can absolutely appoint it. When they decide that it's necessary, our clients are the people who are paying those fees. So I do want to make sure that everyone is very aware that's an existing power judges have right now. I don't think it's something that we need to necessarily force into a statute. But there's a lot of people who focus on pennies on a dollar. This is a very hyper-competitive industry. There are many companies in this space, and for anyone who makes a couple of phone calls, which we put in the last amendment to the NCOIL model, suggesting that all payees get multiple offers before they enter into an agreement, we've tried to do as many of those safeguards we can to make sure people are educated that they have a lot of options here. Similarly with the comments about prior transactions, in the existing NCOIL model right now, there are disclosure requirements for prior transactions. There are disclosure requirements to make sure that people are aware of all the people's dependents and all of that information. So the NCOIL model has a lot of protections right now that addresses some of those very concerns. All right, I'll stop talking and bring the main event to the stage. It is my absolute honor to bring and to introduce the committee the Honorable Omar Maldonado. Judge Maldonado is the judge of County Court of Law number 8 in Hidalgo County, Texas, which is right one of our border states, a lovely, very long 4-hour drive that Mr. Maldonado was kind enough to take this morning and will be doing as soon as we get out of here. Judge Maldonado has a daughter who's a drum major who's going to be performing in a high school playoff game this evening, so I'm going to be quiet and let him take it over, so we need to get him back on the road so we can make that game. But Judge Maldonado, I'll turn it over to you.
Thank you very much, Mr. Deere. To the committee and to Chairwoman Theis, thank you so very much for the opportunity to appear before you today. As was mentioned, my name is Judge Omar Maldonado. As a native Texan, I'd like to welcome each and every one of you to our great state of Texas, the birthplace of the Republic of Texas. In 2014, I became the first elected judge to serve in County Court at Law number 8 in Hidalgo County, Texas, and it is still where I preside today. I have overseen and currently oversee criminal, civil, and family matters, and I have directly overseen countless proceedings involving the transfer of structured payments. As such, I have become familiar with reviewing the sale of such payments and fully understand all aspects, positive and negative, associated with selling a portion or all of the individual structured settlement payments. I've seen the benefits of selling these payments and how it affects individuals. Often, this is one of the largest assets that people may have, and it is my duty as a judge to oversee and determine, after reviewing the facts, that any of the sale is in the individual's best interest. That is always how it has been, and the Model Act adopted by NCOIL in 2022 provides that all the resources and tools for any member of the judiciary to be able to fully and effectively review the facts to determine that the sale is in the best interest of the person seeking to sell their structured settlement payments. Our law here in Texas was adopted based on previous versions of the NCOIL model and in compliance with the federal law requiring a court to make a best interest determination. In my opinion, there is no need at this time to adopt additional changes to the 2022 NCOIL model. When Congress authorized these sales, they placed the responsibility on the court to gather the facts and information and to decide the best interest, and I believe that is how it should remain. Every member of the judiciary who reviews these matters has the ability to personally inquire about the facts surrounding the individual circumstances to determine if it is in their best interest. As a judge, I am free to appoint a guardian ad litem or another advisor to represent the individual seeking the transfer if I, through questioning and reviewing the court's filing, determine that the lack of capacity to adequately determine if the sale is in their best interest. It is not in the case of a minor, the appointment is wholly, of course, warranted. However, not all individuals warrant such an appointment. When Congress enacted the federal law requiring such sales, they placed the burden to make these findings solely on the court, and it is the judiciary's duty to make the finding and to avail itself to any civil procedures necessary to make that finding. Therefore, at this time, I would urge you to not adopt any changes and to review such needs when scheduled for review in 2027. And by doing so, it allows the members of the NCOIL the opportunity to consult with members of the judiciary to see if any additional changes are, of course, warranted. I will say that I was having this conversation with Judge Lopez earlier before this committee convened, and we were talking about how many cases I specifically handle. I am a court of general jurisdiction. On an average day, we handle about 50 criminal cases, another 20 civil cases, so about 70 cases a day, and we handle that in a matter of about 3 hours. Every day I make decisions that I have to use my gut instinct, and it is our job to do that. And with the experience that I have over the last 10 years, I feel like I have been very proficient in doing so. Whether a person's mental competency is an issue is something that I can determine within seconds, sometimes in particular cases, especially in criminal cases. This is no different. I think that if we take that ability away from judges, I think that we're basically stripping them and us of what we train ourselves to do every day. And so I just wanted to make sure that you all understood that, you know, as judges, we handle cases every day. I am a court of general jurisdiction. We hear cases, sometimes, you know, hundreds of cases on a weekly basis, and decisions are made that often involve these type of decisions about what's in the best interest of the litigants and the parties that are in front of us. I stand ready to help to answer any questions that you all may have.
Thank you, Judge, and thank you, all of you, for your presentations. Representative, do you still have your question? Because mine was answered.
Thank you, Madam Chair. I believe mine was answered too, but I do want to just ask this question just in case. What kind of protections are in place to ensure that the structured payments settlements are in the best interest of the payee and their dependents?
So, and since you're looking at me, I think you're directing that at me. So under the, so I'm just going to do my best to answer it, and if I don't get to where you're looking for, please feel free to follow up. So in each of these cases, just kind of give you a perspective, since I handle a lot of these, representing a lot of these companies. What we generally do, and when we're making our presentation to the court, at least here in Texas, and I speak with a lot of attorneys who handle these in other states, and you know, for the most part, it's my understanding most people handle them fairly similarly. But I always start our presentation, and by our presentation, I solicit questions directly from the person involved in the case. I'll typically give the court a very brief overview of the transaction, but it's not my story to tell. It's the person who's involved in that story to tell. And we will go over everything from, you know, their age, if they're married, if they have any children, if they're working, if they're in school, what's basically, I spend quite a bit of time letting the judge know, because this is typically the judge's first introduction to a person. As Judge Maldonado mentioned, they're kind of used to seeing a lot of people over time, but I always want to make sure that the court has a background of who they are, what they're doing, if they're working, if they're recently out of work, if there's someone who was injured in an accident and can no longer work. We always elicit that just because that brings in a little bit more of a need for a judge to pay attention in those cases, as opposed to others, like when I have an attorney who owns their own business. You know, pretty early on, you get to figure out how, you know, how much attention, how much focus, where do the courts need to be focused at to make sure they're getting that information. But we will tell them, you know, through questions to that person, we want to make sure that the judge has the answers about that person. Because we all understand these hearings, they're not multi-hour. Sometimes they are, but usually not. But we want to give the judge information of who that person is, what's going on in their life. We'll then turn into what was the underlying reason that they're receiving this money, because there are certain cases that's a wrongful death case, or a case where I was bit by a dog and I've completely recovered from those injuries. There are some people who still have issues, and we elicit that so that the court knows, because again, that brings an extra little cue to the judge, this, to put a little bit more kid gloves on it. We'll go over the terms of the transaction. We'll spend quite a bit of amount of time of what they're planning on using the money for. Not necessarily required, but a question I always try to ask is, what alternatives have you looked at outside of this transaction before you've gotten to this point? We'll always go over the fact, I always cover that, I always ask, one, under the NCOIL model, we are required, our clients are required to advise people that they have the right to go speak to a lawyer or a financial advisor. If they want to choose to do so in some states it is required that they do so before they move on. I'll ask if they've done that, and then if they haven't done that, I'll then make sure I'll always go over the fact they understand I'm not their attorney. I obviously can't give them any kind of legal or financial advice, and that they absolutely have the right to go talk to a lawyer or financial advisor if they want to do so. And I will always cover that even at this very moment. In this hearing, if you want to take more time and you want to take a pause to go do that, you absolutely have that right. So we cover all of those things. I will, if someone's done prior transactions, I will bring those up because that's facts I want the judge to know. Because we do have repeat sellers. Some people, sell once and they're done. Some people will occasionally come back. I had one very sweet lady, my favorite, and forgive me, I'm going to tell this story for as quickly as possible. I had a very sweet lady who had completed a number of transactions. Unfortunately, her daughter had some criminal issues. She ended up having to take care of her grandchildren, and that brought a lot of other necessary things that she never expected to have to deal with. Her last transaction, she came up and wanted to sit, I called in when I was doing a prep call with this person to get a little background information from them. They told me, I want to go on a cruise and I want to go to Las Vegas. And I'm like, okay, tell me more. And this sweet lady from Dallas County, who lived on the south side of Dallas, who'd taken care of her grandbaby she never expected to, had never been 20 miles outside of Dallas County. And at this point, he's like, Mr. Deere, I want to go on a vacation. I've always wanted to see Las Vegas. So I want to do it while I still can. And I walked up to the judge, and Judge Slaughter in Dallas County, great judge. I walked up, and she's a judge who will routinely, anytime she has a concern, if she has a concern, she routinely appoints that lineups. And I've worked with her for years, but walked up to the bench, like, Your Honor, before I get started, I'm going to let you know that this lady wants to do this transaction because she wants to go on a cruise and she wants to go to Las Vegas. I'm going to tell you her story now, and then you're going to probably say yes to it. And she did. So we have people from all walks of life. So when I say every person's story is different, it is, and we have to be cognizant of that. We have, people who are in these transactions. One of my favorite from this year.
We're going to need you to wrap up a little bit. I'm sorry.
Oh, my problem.
We've got a few more questions yet.
I'll cut it right off on that, but you get the gist.
Thank you very much. Senator Lang.
Yeah, my question was for Victor. Victor, you talked about some states that have put guardians in place. Who pays for that? Is that the taxpayer?
No, in those, it's usually the defendant who is offering the settlement, and that's in the context of minor settlements. So it's whether it's the insurance company or the attorneys for the defendant who caused the injury. Yeah.
Thank you very much. And for the legislators that are interested in the Model Act, it's page 107 in your booklet. Thank you, everybody. If anyone has any further questions on this topic, please reach out to me or Senator Utke. We'll get you any answers for any of the questions you might have. Joining us today is Professor Michael Duff of St. Louis University School of Law. We're going to hold questions for him until he's finished. Professor, you're going to be doing a presentation on the state of work comp coverage for mental injuries. So
that's right, Madam Chair.
Thank you very much. Please go ahead when you're ready.
Thank you, Madam Chair. Thanks to NCOIL for inviting me. The last time that I appeared before you was in 2019 in Austin, and I can tell you that it was the last thing I did before the pandemic. So I'm not ascribing that to you. I'm just stating a fact. So one of the things that I want to say about the whole concept of mental injury, PTSD, that's how everybody knows about this issue, is that when Will Milovchik asked me to come up and talk to the committee, I said, well, Will, what do you want me to say? I want you to bring them up to speed. And of course, to bring you really up to speed would require getting a chart, putting it on a bunch of slides, and going through ad nauseum to show you what's happening in the various states with respect to PTSD. I thought that wasn't a very good idea. So what I want to just do is summarize and update how mental injuries, of which PTSD is one, are covered throughout the country, just in summary fashion. But I think more importantly is to give you my sense of why mental injuries are being covered at all. That is really the hardest thing to be thinking about. My students, by the way, are very glad that I'm here because I'm not. They're not in torts class today. So, but a lot of things happen in the law because there are legal movements that develop, and there's not a better explanation than that. So, if anyone in this room were to say to me, workers' comp doesn't cover a series of injuries because that's just the way it is, that's not going to be very effective with my students who are the up-and-coming lawyers, right? The question is, why is it the way it is? Why is it that for time immemorial almost, it seemed like workers' comp didn't cover mental injuries? And I'm going to explain what I mean by that in a minute. The long and short of it is because tort didn't cover mental injuries. I mean, that's really the bottom line, because workers' compensation, everything that is done in workers' compensation presumes a kind of quid pro quo, a grand bargain, one set of rights for the other set of rights. Well, what I'm going to tell you is that there was no such thing as something called negligent infliction of emotional distress. Did not exist in 1910 when the quid pro quo originated, at least in the United States, right? So there was nothing to exchange. The problem is that as that theory expanded, tort liability expanded. And so all of a sudden you have situations where emotional injury is arguably tied to work, and if you don't cover it with workers' comp, what you're going to get is a tort case, right? That's not speculative. I'll give you one example from my former home state of Wyoming. So why injuries are covered is another part of this. Now, there's obviously a political dimension, right? We see more and more and more PTSD discussion as a matter of public policy. And I cited in the slides here a typical article, just one, from the Journal of Public Health Policy, basically talking about the extent to which PTSD is increasing, the extent to which, particularly with respect to first responders, who see horrible things and do horrible jobs, that there was this upswell of support for the idea. The idea is I see somebody at work, right? My work happens to be that I'm a first responder. It's a horrible situation, and frankly, I am psychologically impacted with that development for some period of time thereafter, right? It's a very simple fact pattern. And so now I attribute a lot of what's going on to the pandemic. And the reason I do is because during the pandemic, we had things like workers' comp causation presumptions that you probably all know about, okay? And the question is, well, why did we have those? And the reason is because we didn't have anything else. And there's not a better reason than that. You could say that probably work played some role in the development of COVID-19. I'm not going to go through all that. But I think what that did was loosen up people's minds and think about workers' comp coverage differently. But you can see, I'm not going to read the statistics to you, but there is this sense that there are more and more and more instances of people developing psychological disability as a result to work-related traumas of one type or another. And as a matter of public policy, we know that there are high-stress jobs, and we also know that people that have high-stress jobs that number has been going up, rates of depression are going up, suicidality is going up, and so forth. All of these things are happening. So there is this upswell of psychological injury, right? Now, the question is, as you well know, is how much of it is related to work, and why should workers' compensation cover this? Historically, we have three kinds of compensation of nervous injury that we talk about in workers' comp law. One is called physical mental, another is called mental physical, a third is called mental mental. Physical trauma, most of us are aware of this type of situation. Somebody suffers a really serious back injury, let's say, and they're at level 7 pain for a year. And what happens? They get depressed, right? And it's been uncontroversial for many, many years that level of that kind of compensation, even though it's a psychological disability that results, the depression, is compensable. So those are the three categories, and it's necessary to understand that's what and PTSD, by the way, falls into the third category, right? A purely psychological or mental stimulation causing mental or psychological disability. Mental, and I don't mean to be, I'm not disparaging, this is just shorthand, a way to talk about it. 34 states cover right now mental injuries, right? Which means obviously that 16 do not. Now what I'm going to explain is that of that 34, 9 states cover mental injuries only for first responders. But there's a group of 34 that cover it in some fashion. Now, they don't just cover it, right? It has to arise out of and in the course of employment, the standard formula that we all know. However, you'll notice there's something I left out of that arising out of and in the course of employment, and it is accident, right? There is not an accident qualifier there. So what states do is, even though theoretically they cover PTSD, they have conditions that have to be satisfied by the claimant before they can be eligible. So, for example, the situation that freaks everybody out, as my students would say, is the idea that there is a personnel action, somebody's disciplined, they're fired, something like that happens, they develop some kind of psychological trauma and file a workers' comp claim. Well, there are many states that say, no, that is not the qualifying event or accident, let's say, that will allow you to file a successful workers' comp claim. Disciplinary actions, job transfers, demotions, layoffs, you get the idea. The idea is we don't want to open up the Pandora's box and cover everything that just seems like the normal way that a business is operated. Some states, like Maine, for example, where I'm admitted, that's my home state of admission, have enhanced proof standards. It has to be, whatever the event is at work, has to be the predominant cause of the psychological disability that results. Not a cause, not a significant cause, not a substantial cause, the predominant cause. Well, that's another way you can say it's covering mental injuries, but not in a sweeping way, because you have to get over that standard. 25 of the 34 states that cover mental generally cover them for any employee. All right, so any employee that can meet the standard that's developed, it's covered. Now, having said that, there are still events. There are still criteria. The event that caused the injury usually has to be unexpected, unusual, extraordinary, not just anything, not just something upset me, right? Just something really unusual. Some states say they're even narrower. They say that the mental injury must have been caused by a specific type of event, being a violent crime victim, witnessing someone's death. Those are really dramatic, tremendously dramatic things, right? So notice what's happening. It's covered, mental is covered, but it's narrowed significantly. So it's going to be very hard to cover. First responders, this is where most of us has heard about this, right? There is a political drive on the part of labor organizations, emergency medical services and firefighters and so forth, to cover these types of disabilities, right? I'm not telling anything I think that you don't know. Some mental states use separate criteria altogether for first responder claims. And I use Missouri, my home state of Missouri, Nevada, Wisconsin. 11 states have a rebuttable presumption. Now, this is the part that really becomes sticky, right? So if you have a rebuttable presumption of PTSD, what does that mean? It means somebody accurately diagnoses a person with PTSD. You just have a diagnosis. Once that happens and it's tied to some work-related event, and I told Will I wasn't going to do this. This is my scaled-back version, right? I go into much more detail. So what happens is that the burden shifts to the employer. Now, prove that it didn't happen because of work. Now, think about proving a negative and how difficult it can be, as hard to prove a negative as it is to prove a positive. So when you shift the burden of proof like that, very often that can relate in coverage. So that group of 11 states, the rebuttable presumption criterion, is really the one that's going to lead to enhanced coverage. 9 states generally prohibit mental claims, but they make an exception for first responders, right? A lot of states aren't doing that, and I would tell you that I think there are sort of constitutional problems lurking in that division. That's all I can say about it. People are alarmed by Connecticut. I don't know if you've been hearing about Connecticut. Will specifically mentioned Connecticut. Connecticut, look at that title there in the second bullet. An act expanding workers' compensation coverage for post-traumatic stress injuries for all employees. That sounds dramatic. Okay, until you get into the small font here and you have a series of really dramatic events that would have to happen, right? And these can happen, but you have to view a deceased mind. I'm not going to go through them all, but they have to be serious events that occur. And if that happens, then yes, theoretically, that is an employee that qualifies. But look at the next slide. It's not a presumption. It's very different from those other standards because that have a presumption. It's not a presumption. The PTSD must, now the words in quotes, directly result from the event, right? So you have really a difficult causation standard there. So it's not anywhere near as dramatic as it looks in the news, because I wouldn't want to be the claimant's attorney, and I was one once, trying to prove the case under that standard. New York is really the more serious one. New York, where a worker files a claim for mental injury premised upon extraordinary work-related stress incurred at work. Now, what I want you to notice about this, you know that whole bullet, all those criteria on the previous slide? It's not there. In other words, you could theoretically have someone who had a cumulative psychological injury over time. And that applies, and that originally applied to first responders. It was expanded. It's passed both houses. I don't know if the governor has signed. I don't know if anybody from New York's in the room, but it was slated to be signed soon. Right now, that is the one that is dramatic. Right, that's the one that suggests, well, suppose I'm at work and over the period of 5 years, I'm just getting more and more stressed because you're a bad boss, and I'm getting more and more and more, and then one day that is extremely problematic to defend, and so forth, and potentially very expensive, because when does it end? How much time do I have? Should I stop?
About -5.
Oh,
We're good.
okay. Believe me when I say that's the short version of this.
It
Thank
was
you.
great information, and it was obvious to me our legislators were engaged, so I didn't cut you off. But we do have a question. Thank you very much for your presentation.
Thank you.
It's actually really informative and very thought-provoking. Representative Lehman?
Yes, thank you. Are we on? Can you guys hear me okay? There we go. Thank you. And everything you talked about is all about the presumption of the injury, when, where, how, and why. My question is more, how do you calculate the compensatory damage? You know, when I break a leg, I go have surgery, I get so many days off work, all that statutory, either you get X amount of hours or you get the medical bill paid. How do you calculate if the compensatory damage on a mental claim?
It's not a problem with temporary total. It's not a problem with permanent total because that's all a function of the average weekly wage, right? So that's just math. The problem is permanent partial disability, when that permanent partial disability is scheduled and you have some combination of scheduled injury and unscheduled injury. So that is a great question, because if you have partial disability that's not scheduled, that could go out into time, right? And I will match your question with a question, which is my way. How do we even know when the disability ends? You have problems with intervening causation that are really significant.
Yeah, because that would be my concern, is there's other factors that go in potentially to mental illness. And so is this, we had a gentleman who was going through a traumatic time in his life and then witnessed a death at work. I'm a broker in the insurance business. And the mental stress was caused by which had a greater impact on his mental stress, the life issues or the incident at work? And then how do you say what category that's in? Is it permanent and partial? And that really shed the light on, we can begin to statutorily say what is the cause, but I think we really need to be working also on the end of that is, where do you put, in what bucket do you put that when it comes to the compensatory side?
I think you're going to run into, you're going to have rules like that deal with the extent of time that a particular kind of claim would be paid, and those kinds of things. Yes, I agree.
Thank you, Representative. Representative Tedford?
If you could talk a little bit about the New York law and the cumulative trauma kind of approach they're taking, and how it would be dealt with in a workers' comp policy setting where the coverage trigger is by an occurrence, and how they deal with that. And you could have trauma that goes over multiple, even policy periods, multiple carriers. How are they dealing with that?
Yeah, well, how they're dealing with that, of course, isn't clear because it's new, right? And the whole concept really is new. It's newer, right? But there is a big difference between a serious one-time event that causes somebody psychological disability and something that's more like over a period of time, the person is just experiencing high anxiety in a workplace, and at a certain point, right, the straw that broke the camel's back, or whatever, so to speak, right? And you have a what we call in torts the eggshell skull plaintiff. You can have the eggshell skull person with respect to psychological injury. Right, so somebody is just experiencing more cumulative anxiety than somebody else. And how do you deal with it? These laws are going to have to be tailored. And by the way, this is all a factor of non-coverage. I mean, that's basically what's driving this. People woke up one day in the pandemic and said, oh, this isn't covered, and this isn't covered, and this isn't covered, right? So now we're rethinking, and the same thing has happened in tort law over 100 years.
Thank you, Professor. Thank you, Representative. Last on our agenda is a presentation from the Texas Workers' Compensation Insurance System, which is kind of unique. It was fascinating to read about. With us today is Jeff Nelson, Commissioner of the Texas Workers' Compensation Insurance System. We're going to hold questions until he's finished. Thanks for being here. Please go ahead.
Thank you, Madam Chair. Thank you for having me today. I know we're running a little behind, so I'll try to be quick. I do want to echo some of my counterparts up here. I hope y'all are enjoying your time in Texas. Welcome to our great city. Welcome to our great state. I really hope you enjoy it. So I was asked to talk a little bit about what has made the Texas Workers' Compensation System successful and what has made us unique. And I think those two things go hand in hand. I think a lot of the successes we have in Texas has been thanks to sort of some of the political fortitude over the years and some of the major changes that the legislature has undertaken to put us in such a good position today. Before I get into all that, I wanted to just give a brief sort of snapshot of who we are as an agency, then sort of what the workers' comp market's like in Texas. So for starters, we are the Texas Division of Workers' Comp. We are the regulator of the system. We're neutral. We do not advocate on behalf of injured employees. There is a separate state agency called the Office of Injured Employee Counsel who does that. We have over 400 FTEs in our agency. They're spread out across our 20 field offices across the state, although most of them are in our Austin field office just across the street from the Capitol. We are funded by a self-leveling maintenance tax on workers' comp carriers that is capped at 2%. We have 5 main legislative directives given to us. And those are dispute resolution, healthcare management, claims and customer services, workplace safety, and then of course, compliance and investigations since we are the regulator. So that's who we are. Now, what's the market like in Texas? Texas has a very healthy workers' comp insurance market. We have over 300 insurance carriers that write comp, and they write about $2.6 billion in direct written premium every year. Now, even though we do have those 300 carriers, the top 10 carriers make up about 75% of the market, and Texas Mutual is by far our largest carrier. They make up about 41% of our whole market. Since some of the reforms that I'm going to get into in a little bit, in 2003, workers' comp rates are down 81%. And that's something we're very proud of while we're seeing better outcomes for injured employees. One of the signs of a healthy workers' comp market is how big or small the residual market is. And we are very fortunate in Texas that our residual market is below 0.3% of the overall system. And it's been good for insurance carriers too. Workers' comp has been the only consistent, profitable line of insurance for carriers in the state for at least the past decade. So that's a little snapshot of how the system is, who we are, but what makes Texas different, what makes us unique. And like I said, it's really about the legislative reforms that have gone on since workers' comp started in 1913, but really since 1989. So that's what I was going to dig into a little bit today. So I'm going to tell there's always legislation going on with workers' comp, just like any other system. But what I wanted to focus on today are these 3 changes. First, when workers' comp started in 1930, some major reforms in 89 and 2005. And then it wasn't really until 2010, 2011 that all of those 2005 reforms got implemented. So those are going to kind of go hand in hand together. So for starters, in 1913, that was the first workers' comp law that was passed in Texas. And since 1913, we've been unique. Workers' comp has been optional for Texas employers since then. I think we're one of only 2 states where it's optional for employers, and it's really worked out well for us, I think. Now, we do employers that do not have coverage, we call them non-subscribers, and we do track those numbers. Now, even though employers have a choice to get coverage or not, 76% of all private sector employees do carry workers' comp, and they cover 87% of all private sector employees in the state. So it means that these employers think workers' comp is the best route to go for them and for their employees. And I know this makes us very unique, and when I talk to other states about this, they think it's kind of weird, but it works out well for us, and I think it's been a driver for some of the changes that we've had. One of my old bosses, Rick Perry, he used to talk often about how competition among states drove innovation. He would call them the laboratories of innovation. And I think that's sort of what's happened in Texas. We don't have a captive workers' comp market. Employers don't just have to get comp coverage. They can choose to go another direction. And because of that, the legislature has put in programs and policies 10, 15, 20 years ahead of sort of what the standard has become now. So I really want to give an appreciation to the work that the legislature has done and the foresight that they've had to put us in such a good position today. So the first major reform was in 1989, and these were significant changes to the point that anything prior to 1989 we call old law, and anything after 1989 we call new law. They wrote an entirely new code. Of course, there were a ton of changes there. I really want to focus on 3, and I'll be quick in it. First, they eliminated pretty much all lump sum medical settlements. They created a new dispute resolution process, and they limited attorneys' fees to 25% of the employee's recovery. And that first one, eliminating settlements, has had a huge impact that's been lasting today. The Workers' Compensation Research Institute, a national organization who does workers' comp studies, recently published a study comparing 17 states and their overall claims costs. What they found is that Texas has the second overall lowest claims cost of all these workers' comp systems. We were 32% below the average. And they directly attributed our low claims cost to the fact that we did not allow lump sum settlements in our system. The other thing it did is it created our modern dispute process. This was another effort to sort of bring attorneys out of the system and to reduce litigation costs to really simplify that process. This is very similar to how it is now in most states. Informal mediation we call a benefit review conference, a formal contested case hearing in front of an administrative law judge, and then go into our 3-judge appeals panel. From there, you can of course go to district court, but these changes have really had lasting impacts on our system, especially the changes with settlements. At that time in 1989, costs were out of control. Businesses were fleeing the state. 70% of claims were going to litigation and ending in settlements. Injured employees weren't getting back to work. They didn't want to get back to work. So that one change has really had a lasting impact on our system. Things kind of cruised along for a while. Then in 2005, we had another set of major changes that really drove some of those significant cost savings that I was talking about. Again, there are multiple changes to this bill, but the major changes I want to touch on is it created the Office of Injured Employee Counsel, required us to develop treatment and fee guidelines, and it had us adopt a pharmacy formulary. So the Office of Injured Employee Counsel is a separate state agency that's very unique to Texas. This is an agency that is funded by the Workers' Compensation Maintenance Tax, and it is made up of a team of ombudsmen across the state whose job it is to assist injured employees through the dispute resolution process. It's an alternative to them having to hire attorneys to navigate the system. These ombudsmen are not attorneys, but they are specialized in the dispute process. They know the ins and outs, to the point where 50% of all injured employees in Texas choose to use an OIC ombudsman rather than hire representation to take them through a case. OIC also offers various educational opportunities and just claims help with the claim, right? Help with how to file paperwork, reminders that they have doctor's appointments coming up. And it's been really beneficial to the injured employees in Texas, and it's been a cost saver as well. And that wasn't a difficult thing to do, creating a whole nother agency to essentially advocate against insurance carriers funded by an insurance maintenance tax. But it's actually been a cost saver for all parties in the state, and it's been very beneficial. What I think the biggest changes were, though, during those reforms was instituting treatment and fee guidelines. The treatment guidelines created a standard way to handle the medical portion of claims. It said what treatments would be pre-approved and what required pre-authorization, and it really just brought in a standardization of care. It also introduced fee guidelines, and by statute, we were required to make those Medicare-based. And I thought that was very smart for 2 reasons. First, healthcare providers understand Medicare billing. Their front offices are familiar with it. It wasn't much of a change. The second thing is we tied it to an inflation factor, the Medicare Economic Index. So every year, our fees are automatically adjusted. And this has helped tremendously without, we don't have to go to the legislature every 5-10 years to have a big fight about what the fees are. We don't have to undertake a 3-year rule project to discuss what fee changes need to be made. They're automatically changed every year, and workers' comp systems around the country are struggling with healthcare providers in the system. And I'm not saying we don't have those challenges, but doctors in our system know they're going to be paid. They know the fees are going to consistently be updated, most likely increased. But it's been very helpful in that regard, and I thought that was a very kind of prescient decision that was made.
Can you wrap it up in
Sure.
about a minute or so?
Here's what all that did. Even with all the healthcare inflation going on, a 30% reduction in overall healthcare cost, a 20% reduction in total claims, 26% reduction in professional services, 20% reduction in hospital, and a 71% reduction in pharmacy fees. I think we can be held up as an example for how to have a successful system, and I think it's thanks to the Texas legislature for putting the work in to get it done. Thank you.
Wow, okay. You took that minute seriously. Thank you very much. I appreciate that. I thought the last few slides were particularly striking as I was going through and reading this in advance. So thank you, and thank you both very much for your presentations. I appreciate it. Legislators, are there any questions? Not. Thank you again very much. Appreciate it. If you do have any questions that you come up with, you know who to reach out to, and we'll make sure we'll get the answers for it. Next up, we have any other business, and Rep. Nickel, you had something quickly you wanted to mention?
Thank you, Madam Chair. I did want to mention that this week is National Kids Chance Awareness Week, and I'm on the board of the Montana Kids Chance, and it's a great organization. I just want to make sure everybody knows even what it is, and it's what we do is we give money to kids that have had parents injured or killed in a workplace injury, or workplace accident, excuse me. And it's a great program, and I just wanted to do a quick shout out to let you know about it. Please look it up, and if you would like to donate any money, go ahead and contact me. Thank you.
Thank you, Representative. Is there any other business properly before this committee? Do I hear a motion to adjourn? All in favor? Aye. We are adjourned.